when we speak about the Gyanvapi Mosque Kashi Vishwanath dispute, there's also this question about the right to worship aspect. Even as we speak, this question is being deliberated upon in a Delhi court today on the Qutub Minar complex case. The court is in fact questioning if right to worship is an established right vis-a-vis the constitutional rights. What is your response to it with regard to the Gyanvapi Mosque case?
See, right to worship is a fundamental right. It's the most important right for all the devotees across the country. It's enshrined under Article 25 of the Constitution of India. And apart from that, the Hindu law, the customary law also provides for it. Now, the question is, so far as the issue of Gyanvapi is concerned, after the commission and after the survey is over and the shivling which has been found, our aspect is and our point of contention is, bone of contention is that this particular property has all the characteristics of a Hindu temple. And my deity is existing there, my shivling is existing there, so it can never be a mosque in view of Islamic law.
Right.
So therefore I have a right to worship there, and if you'll see my plaint in my prayer A only, there is a categorical averment and there is a categorical prayer seeking darshan puja of Lord Ganesh, Lord Hanuman, visible invisible deities, Ma Shingar Gauri, and other visible and invisible deities inside the so-called Khasra number 9130, which they call as mosque, we call it as temple.
Right.
So we have a enshrined right under the constitution, we have a right under our customary.
Regarding Places of Worship Act, you say that that is a major arsenal which the Hindus have, which the Muslims have in their petition before the court. How do you respond to that?
See, the Places of Worship Act is a tricky argument for so far as Muslims are concerned, because in the Places of Worship Act, Section 4, Subclause 2 uses the word religious character. And during the discussion before the Supreme Court, this word was deliberated, that the religious character also has to be determined just by a person saying that this is a mosque. It can't be a mosque forever.
Right.
If I am saying that it's a temple, and if there's a proof that temple was made after demolishing a mosque, it can't be a temple. So these are the things which have to be ascertained while determining the religious character, that whether a temple was existing there, which was demolished and converted into a mosque, and what is the religious character of the property in question. And after the commission report, when shivling is found, the religious character of that property is of a Hindu temple. So Places of Worship Act will apply in my favor. And what about the Places of Worship Act when till 1992 Vyasji used to do puja there, and in violation of Section 3 the status quo was converted.
Right.
So the point in issue is that in whose favor Places of Worship Act will apply, that is subject to evidence.
Will there be an end to this when we see about religious structures being, excavated and remains of other temples being brought forward?
There'll be an end to it when we get all our cultural heritage restored. If there is a temple which has been destroyed, our legal team and our entire fraternity will try to fight for restoration of our glorious past and our temple and cultural heritage. Until that time, we will not stop.
For example's sake, if you consider that the maintainability of the suit is decided against you, what is the road ahead in this?
But even assuming that, okay, a Places of Worship Act, because of Places of Worship Act, my suit is barred and my plaint is rejected under Order 7 Rule 11, I'll file an appeal before the Allahabad High Court.
Subscribe to our YouTube channel and click the bell icon.